Well, hello everyone and welcome. Welcome to the very first edition of our new series of conversations with global leaders in law. And you're in for a treat because we have a truly remarkable person as our first guest. My name is Richard Albert. I'm Professor of World Constitutions and Director of Constitutional Studies at the University of Texas at Austin. This program is co-sponsored by the Constitutional Studies program and also the International Forum on the Future of Constitutionalism. Being able to host all of you today is a great joy. And for me, it's just another reminder of why I love my job so much. It's a job I get to do here on the campus of the University of Texas at Austin, a campus located on the indigenous lands of the Tonkawa. Their stewardship of these grounds has given me the gift of living a life of learning and discovery. And so I honor the Tonkawa, and I ask you to join me in doing the same. A few weeks ago, the eyes of the public law world were focused on Kenya. The Court of Appeal held a multi-day hearing on an important case, a case involving what is known as the BBI initiative. We'll talk more about that in a moment, but for now, all you need to know is that the case is enormous, it's interesting, and accordingly, it drew the attention of constitutional law scholars all around the globe. We were treated to masterful presentations and arguments at the hearing, those of us who watched it. So many great lawyers modeled what it means to be an excellent advocate. And one of those lawyers is our guest today, Esther Ang'awa. Esther, you captivated so many of us watching, people in Kenya and abroad. You were eloquent and poised and powerful and compelling. And I myself felt compelled to try to twist your arm into spending some time with us today so we can get to know a bit more about you, about your background and your experience and your journey to this point. And so our plan is to have a conversation with you, to learn about you, and really in learning about you, to celebrate you and what you've accomplished thus far, and also to learn about your plans for the future. And so Esther Ang'awa, advocate, the High Court of Kenya, and our first honoree in this series on global leaders in public law. Esther, welcome. Good to see you.
Thank you very much, Professor. How are you?
I'm doing well. It's really marvelous to have the chance to see you and chat with you and introduce you to some persons who don't yet know you. That number is growing increasingly smaller and smaller, I should say, because you're becoming very well known for your submissions and your work. And also, people are learning about you outside of the law. You have some passions that I think are worth sharing with others. But let me begin with a first question, if I could, which is, you have a connection to former President Barack Obama, don't you? What is that connection?
Yes, I do. I think most people would say the first connection would be that his father was Kenyan, and from my tribe, the Luo. But that's not really what gets me excited about our connection. I was part of a leadership training program that was first founded by the former president, Barack Obama, the Young African Leadership Initiative, YALI. And I was a student of their East African Regional Learning Center here in Nairobi. That was a few years back in 2016, I believe, and late 2016 and early 2017. And I learned a lot on how to be a leader. The training was immense, intense, 3 months of all manner of knowledge sharing from, teachers, both locally present and some from the United States. And it was a great experience. So I'm happy to be part of that family of young African leaders that were brought up thanks to this wonderful initiative by President Barack Obama.
And so the work continues. In fact, today you had an engagement with YALI. Tell us about the kind of work that you continue to do with and around Yali?
Well, today we held the third Youth Leadership Summit, still in Nairobi, at what we call the Kenya School of Government. I was one of the panelists leading the discussion on strengthening the involvement of the young people in policy making, governance, and politics. And it was exciting because we get to share experiences with other young people who've come after us ever since I left the Leadership Center, which was 26 cohorts ago. So there have been 26 more cohorts of young men and women that have gone through the training program. And we've got so many other young people that follow Yali and are engaged in activities of Yali. So we had a wonderful day today, just going through what we can do to strengthen the voice of the young people in the governance of our country.
And what's the message you shared with the audience today? A couple of items that you shared with them about how, in fact, you can do that to ensure a greater voice of younger Kenyans, I suppose, younger Africans, younger persons in their own jurisdictions in being involved in matters of democracy and the state.
Getting your voice out there, just speaking in whatever space that you have, being part of the process. We have, fortunately, under the Kenyan Constitution, we are able to petition Parliament as a right. We are able to be involved in public discourse on implementation of policies, on drafting of legislation, on following up on what the government is doing, on the budget making process, what funds, what public funds go to what activities or services that are rendered by the government. So our constitution is quite people-centric and enables various avenues wherein the citizens can engage with government. And so my plea to my fellow youth was that we must take advantage of all the avenues that we have in our constitution, all the avenues that we have through the civil society space, all the avenues that we have engaging whether with the private sector or with government to put our voices on the necessary issues that we would like government policy to focus on, the issues that we would like implemented. We have so many policies, and that came up in the discussion today, that we have so many policies that have been crafted, beautifully done. However, they're not being implemented, and those that are being implemented are not being monitored. So we cannot know whether there actually is a connection between what policies are being implemented by the government and whether or not they are speaking to the needs of the young people or the needs of the society in general. So the discussion was basically around that. And I encouraged my colleagues and young people in the country, firstly, to take advantage specifically of the strategic public interest litigation, which is pretty much what we were doing with the case on the BBI. Several individuals of like mind with interest to have their voice heard in this process that they felt was not inclusive of everybody. And the best avenue to do that was through public interest litigation. And I encouraged my colleagues to take advantage of that because it's something that we have entrenched in our constitution and which we can explore to make a greater impact.
I want to come back to the BBI appeal in a moment. And for those of you joining us, there'll be time for questions and comments from you in just a moment. But first, if I could, I imagine today you were quite inspirational to those who were listening to you and getting a chance to meet you. Who inspired you when you were at that stage? Did you have an Esther Ang'awa speaking to you, encouraging you, motivating you, inspiring you?
On the stage, regarding the BBI, I'll say my greatest inspiration is Nelson Harvey, my senior and the president of the Law Society of Kenya. I had the pleasure and honor of working with him on that brief and learning great things about constitutional litigation, about constitutional law. I remember he'd joke all the time whenever we would be buried in books and literature from the early 17th century all the way now. He'd always tell me, you know what, Esther, this might just be it for you. This is my retirement brief, but it could just be the brief that gets you to where you need to be. And it was all a joke until that day and that moment. In the High Court, no one paid attention to the matter, so it was just us and the court. It wasn't a public hearing, but I guess time happens and everything happens when it is intended to happen. So yes, at that point on that stage, he was my greatest inspiration, and I guess because we have worked really hard on this particular one.
Yes, yes. Well, he's earned the respect and admiration of many persons as well. When did you know you wanted to be a lawyer, a litigator?
I didn't know I wanted to be a litigator. I knew I wanted to be a lawyer when I was much younger. I felt often that I could not help those who were going through injustice if I did not know anything about justice, if I did not know anything about the law. And when I was about, I think, 10, we had in church a judge who had shared my surname, Angawa, Lady Justice. She's now out of the bench, Lady Justice Mary Angawa. And so I always felt that I wanted to be Lady Justice Angawa as well when I grow up and help people. So I thought always that I would be on the bench. I did not think I would be a litigator, but I enjoy it. I've loved litigation. I think it gives me the space to be myself. I think the bench would be a little more boring. Not that judges live boring lives, but for me, I think I like it on the bar.
Well, they may come calling and enlist you to be a judge at some point down the road.
Think about it.
Did you love constitutional law as a law student? Did you fall in love right away with the subject?
Not quite. Not quite. I think I've fallen in love with constitutional law in practice, not quite at the university. The concept seemed a little abstract then, and I joined the university before the enactment of the constitution that we now have in Kenya, which was promulgated in the year 2010. I joined the university in the year 2008. So when all of that was happening, I was in school, but I didn't quite put my mind or my thoughts, much thought into constitutional law or the Constitution. But the beauty of our Constitution is that it's quite simple. It's an easy read, even if you were to read it, it sounds like a novel. You can quite understand what's happening. And I think what made me love constitutional law thereafter is because of all the things that we can do under our Constitution, all the avenues that we have to reach out to court. I do not need to have to be affected in any way to go before a court of law and seek a remedy under the Constitution on behalf of any other people. So that just made me love constitutional law. And I think litigating it, especially in the past year, alongside Mr. Harvey, who is a brilliant brain and makes everything come to life in a way that it ordinarily wouldn't, has increased my interest in it. Yeah.
And so what was your favorite subject in law school, if not at first constitutional law?
Criminal law. But I think it's because I had an amazing lecturer. God rest his soul in peace. He died, but he made criminal law so beautiful. It didn't feel like a burden learning it, because he had a way of teaching it. He'd use analogies, and he made everything rather simple and easy to grasp. So that was my interest in the beginning. Now I don't even take criminal briefs.
Well, it makes sense to me, because one of your passions is social justice, which of course includes, if we think of it broadly, expanding the scope and the stage for younger persons to be heard, to be seen, to be involved. And so it makes sense to me that criminal law is something that really drew you in right away, separate and apart from how engaging your professor, the late professor was. So that's great. I fell in love with con law right away in law school. My professor was Kate Stith, and I took con law in a small group of 20 students. And so it was a seminar on constitutional law, just really a lot of fun, a lot of fun, and challenging, of course, but really enjoyable. And I ended up taking maybe 12 con law courses or so in the course of my law school career in just 3 years. So I really stocked up on con law classes. So we're getting more people joining us, and I'm now happy to open the floor to questions, but let me continue as we see people raise their virtual hand. And let's maybe ask about the BBI appeal. Are you able to just describe generally what it is? And just let me ask those of you who wish to make a point or ask a question that we can't get into the particulars of the matter or the merits of the matter. And so just take some care in how you phrase your question. But I'm more interested, Esther, in the preparation for the BBI hearing. How much time did you devote to that? How intense is the preparation? And are you able to manage other matters alongside this one? Because I know that you have your own firm, and this is just one of the matters that you're working on. And so are you juggling many matters at once while the hearing is in preparation and as it's actually unfolding, or are you pressing pause on those things?
We didn't have the luxury to press pause, because there were other matters that were equally urgent and deserved attention. So what happened was that we had to put in immense sacrifice in terms of sleep. We hardly slept. We had to read a lot and read long hours and read lots of material because the pleadings themselves filed by all other parties. So for those who may not have followed through in the High Court, we had 8 petitions, 8 separate cases that had been filed. And ours was the lead case. So when all these 8 were consolidated, then we had to go through all the pleadings filed by all the parties, and they were running in the thousands. And we equally had to read all the authorities that had been cited by all the parties in order to, distinguish this or see what supports which argument that we had. So it took a lot of time, and we did dedicate towards the hearing, days of hearing, we would dedicate about 3 straight days when it was all just, we wake up, eat, sleep, BBI for the few hours that we got to sleep. But it took a lot. It took a lot of both mental and physical energy to get through the preparation that needed to be done for the matter. And I'm sure that goes for all the council who are involved in the brief on either side of the brief.
And so where are we now in the BBI appeal? We're expecting a judgment in a few weeks, and just lay out for us what we can expect in the weeks and months ahead.
Well, we have the judgment date set for the 20th of August, which is about 4 or so weeks from now. I cannot predict what the Court of Appeal will do. Of course, it is our hope and prayer that given all the work put in and all the submissions made before the 7 judges, that they will uphold the decision of the High Court. Of course, a lot of the issues in the entire BBI case and the issues surrounding it have a political connotation. So we of course cannot control what the political class do. As a matter of fact, a friend of mine brought to my attention yesterday a public notice for public memoranda and public participation scheduled for various dates in the coming month, relating to one of the amendment bills that we had annexed to our initial petition before the High Court through the parliamentary process, because we have, of course, for those who have been following would know, we have a constitutional amendment through the parliamentary initiative provided for in our constitution and through the popular initiative. And because our petition was not specific to the BBI process itself, it was more, it was broader. It had nothing to do with that particular amendment bill, but we had issue with about 23 amendment bills that were pending before Parliament and which related to the parliamentary constitutional amendment process. And one of them has been put up for public participation now. So as I say, we cannot control the parliamentary process, even though what they have put up for public participation is part of what we had in our pleadings before the High Court. And we are hoping that by the time the judgment of the Court of Appeal is delivered, we will have a little more clarity on how we will deal with those issues, because it seems the political class have decided to use another avenue to achieve some of the things that they wanted to achieve through the process that was halted. So we wait to see. I mean, it's very unpredictable now, again, because we cannot seek the court to halt any parliamentary process, because there's, of course, separation of powers and the duties of Parliament. The court cannot stop them from legislating. And some of those bills were initiated through the parliamentary initiative. So we wait to see. We'll make the decision when the time comes after the delivery of the judgment here.
Now, this case has attracted a lot of attention, certainly in Kenya, but really around the world. Were you surprised by the interest that the case drew from beyond the borders of Kenya?
Well, I personally, I wasn't surprised that it drew attention from beyond Kenya. And I think you'll allow me to disclose this. when I was researching for the submissions before the High Court, I did see a tweet by yourself and on relating to your book that was, I believe, published last year. And I reached out, and I remember you had an interest in, okay, so what's happening in Kenya relating to this matter. So I did know there are a few con law scholars and practitioners who had taken interest in the process. I did not expect the greater interest that ensued, but I think it's because the Court of Appeal proceedings were publicized, and everybody could watch them across the globe. And even now, I believe there is another con law scholar, must be Batum, if I'm not wrong, who's sort of analyzed even the submissions in court. And I think it's interesting. It's interesting because it really is a process like no other. I may not know of the the constitutional review processes in different countries. Yourself or Professor Rosnai, I can see him on, may know because you read a lot about that and interact with those and have researched on different processes in different countries. But I think in Africa, for certain, this has not been done before, and it really is, I think, good that people across the globe are interested in what is happening in Kenya, and we are hoping that they will continue to be interested, and maybe more scholars can study it more, study our constitution more, study the process and what it is that we're battling in court, and it will help, of course, build jurisprudence. It will help build content for the younger scholars in constitutional law. I think it's a good thing.
Mm-hmm. And so I've asked about whether you were surprised that the case itself would draw so much interest. Now, were you surprised that you yourself drew so much interest? There were articles written about you and people talking about how well you did. No surprise to those who knew you, I'm sure. How did you react to that attention to you specifically?
Well, firstly, I did not expect any attention to me specifically. I must say I was going through a very difficult time personally at that point. I had lost two very dear persons to me in the previous week, and one of them I had buried the day before the hearings began. And so I was pretty much in my own world, and I just had to do what I had to do, and no, I did not think that I would. I'll confess, I have not even watched my submission, so I haven't seen it. I haven't seen what you all saw or what the people saw. It was just part of work for me, and especially after all of that, which I was seeing, I think, more than 48 hours later, because I had to go home and still do some more reading. And the following day, we were still in court, and there were still other interlocutory applications that had come up, which we needed to respond to. So I didn't expect it, because I really was just doing the work that I had, taken so much time to prepare for, and I didn't expect all of that. I didn't. I also still think it is a little, what would I say? Or maybe I should watch the submissions first. Maybe I'll understand where you're all coming from before I can conclusively say that it's not merited or it's merited. I haven't watched it, but yeah.
Well, I suggest that you watch it when you have the time. It's really a work of great advocacy, and I suspect that even you, who very likely holds yourself to a high level of excellence, even you will be impressed, if I may say. I'm looking at our list of attendees, and we see many countries here represented. I think this is a reflection of really the interest in you and the subject of your work. We see Israel, which you've alluded to. We see India and Peru and the United States, of course Kenya. Just a lot of people who are interested in getting to know you. So let me just invite anyone who'd like to make a point or ask a question. Use the virtual hand raising feature, and then we'll invite you into the conversation. And as we wait for that, let me ask another question, if I could, which has to do with what you think makes a great advocate. So when you're looking at either on TV or live, someone making submissions before a court, what are the criteria for an excellent advocate?
My pupil master, I consider myself to have had more than one pupil masters because I trained closely under more than one person and I learn every day. I consider myself a pupil of any person that gives me the opportunity to learn under them. The first one who introduced me to the field of litigation, his name is Fred at work. Fred taught me that you win cases in chambers and not in court. And he said, it's all about the work that you put in your chambers. If you don't put in the work in your chambers, you can't put it out in court. So you've got to prepare, and prepare. I must confess as well that I did take part in a trial advocacy training by another wonderful American, if I'm not wrong, American tutor. Guy, if I'm not wrong, I forget his full name. And it was 1 week's immense training as well on trial advocacy, the art of cross-examination, the art of making submissions, telling your story, and putting your thoughts together in a concise and clear manner without losing the judge and not getting thrown off by questions from the bench. So I do not think that I have ever put in what I learned then, which was about 3 years ago in practice, and until this matter. But I don't. I still must say that you've got to do it often. You've got to train. You've got to be deliberate about what you want to tell the court and what you need the court to know. The second thing that I think would make a great advocate is what Nelson Harvey tells me every time we are preparing for a brief, and he says, stop concentrating on your opponent's case. That's their case. Tell the court your story. Tell the court what you need it to remember when it retires, to consider what you're saying. Because when you focus on their story and you're trying to poke holes in their story, you may spend all your time fighting their fires and forgetting to build up on what you need the court to understand. And so I think even in my mind, as I was submitting before the court, there were very specific things that I needed the court to remember, and I needed the court to distinguish. And I felt that if I could spend most of my time telling the court what it must remember, at least from my point of view, then I'll have done justice to my client's case and not focusing on what the other side is talking about. So yes, preparation and consistency, just working at it and really telling the court your story or your client's story and what you need them to put in mind and what you need them to do for you.
Oh, that's great. That's great. A nice little cheat sheet for how to measure yourself as an advocate. I see we have a couple of questions, so if we could, we'll go right to the floor. Let me invite Manuel Hosea to please ask your question, make your comment, and just introduce yourself first, if you could. And then the floor is yours. Are you there? Well, let's try maybe John Wamrawa first.
Good evening, everyone. How are you? From Eldoret, Kenya. I teach law. I have an interest in law. And Esther, thank you very much for inspiring a great. Sorry, I can't put my video on. I'm not anything right now.
That's okay, but maybe if you could just speak up a little louder, that would be a bit better. Thank you.
Is it better now?
Yes, yes, it is.
Okay. Esther, congratulations. You have made us proud. Those of us who have known you and have seen you grow. And number two, I just want to ask, irrespective of the outcome of the Court of Appeal process, what do you think is going to be the legacy of the High Court position of the BBI process? Thank you.
Thank you for the question.
Okay, I could answer that as we wait for Manuel. The legacy of the High Court decision, whatever the outcome of the Court of Appeal, I think firstly, the fact that the High Court got the entire country thinking about, talking about, reading about, discussing the Constitution of Kenya. I think that's one big win for our country. Before the High Court decision, you know, and the entire process could be seen as the concern of just a few people or certain classes of people, either lawyers or teachers of law or the political class or, those few Kenyans who took interest in the Constitution. But firstly, and I'll say this, the day the judgment of the High Court was being delivered, I was on my way from Nairobi to Migori. Migori is my home, ancestral home, away from the city. And I had to catch a flight to Kisumu, which is where there's the nearest airport before I drive down to Migori. And the judgment was scheduled for noon. I had a flight at 3 p.m., at 4 p.m., but I needed to check in by 3 p.m. And I knew that between noon and 3 p.m., they would have finished reading the judgment and I'd get on the plane and, be on my way. The judgment delivery was delayed until about 3 p.m. And I'm in the airport and they start reading the judgment when I'm boarding the plane. And when I landed in Kisumu, which is about 45 minutes away by air from Nairobi, everyone in the airport was on their phone watching. When I got into the cab, the driver was watching the delivery of the judgment, and these are regular Kenyans, people who probably did not understand what the whole litigation process was about, but it got everybody talking. I got to the hotel. I mean, everyone is listening to the delivery of this judgment, which judgment was read up until, I believe, about 10 p.m. in the night, from 3 p.m. Those were many hours. And the fact that the entire country was glued to their television or their phone on YouTube for that entire period said something. It was a defining moment for our country, that our people care about the foundational law of this country, and are concerned about what the courts say. And there were a few people, of course, that called me, who know me, and they said, we felt that we were going through such a difficult time, and there was this burden on our shoulders, and the court just sort of lifted that up. It's like we were covered in this cloud, and we didn't really quite know what's happening. But and I think it also gave a renewed confidence in our judicial system, that the court can stand for what the people believe is the rule of law, and make a pronouncement that would, if any of you have been following, you probably would hear the mantra, "Nobody can stop reggae," because the BBI was our reggae, and no one was going to stop reggae. And and when this happened, everybody said, "Well, the court has stopped reggae." So I think that renewed confidence in the judicial system is a big win for Kenya, arising from the judgment, and the fact that it piqued our people's interest in our constitution and what it can do for us, and what especially the history of our constitutional process making that was captured in the judgment, sort of helped even those like my younger sister, who was really very young when this process was happening, and if part of it happened when I was a child. So it sort of puts us all in perspective about where we've come from, and gives us a good summary and of where we are, and what we can hope for the future. So John is also my teacher of law. He's a doctor of law, and he taught me in my last semester. I'm currently undertaking a master's at the University of Nairobi, and he was one of my teachers. So thank you, Mwalimu. Mwalimu is teacher in Swahili.
Wonderful. Well, welcome to you, John. Yaniv Rosnai, please.
Thank you very much, Richard. Thank you for hosting this great event. Esther, congratulations. Welcome. It was a pleasure to watch you do your job at court. Let me just say that I think that this case would have implications, of course, the High Court, but also let's see what the Court of Appeal does, would have implications not only for Kenya, but for greater Africa, and many other countries, but also outside of Africa. So Richard has mentioned that we have participants here from Peru. There is right now a pending case in the Constitutional Tribunal of Peru, precisely on similar questions, whether the people, when they are involved in the amendment process, whether they are limited by, let's say, implicit limits to the Constitution. So I think whatever the court would say in August 20 might reach other continents as well. So I think we should all be grateful for you for advancing our constitutional theory and understanding. Let me just ask you one question, and feel free to avoid the question or not answer it fully if you don't feel really willing to do it. You've mentioned faith in the court following the High Court decision, and I completely understand why. And I'm just curious about what might be the implications for judicial independence following decision of the Court of Appeal, either way it goes. Because certainly if the court will accept your arguments, this would mean going against really powerful political actors. And Richard has an article on what makes court supreme, and one of his claims is that when courts decide such high magnitude cases of judicial review of constitutional amendments, this is what makes them really supreme, because basically we're turning courts the final arbitrators of society's values in many ways. But this is also a risky business, because when courts engage in such uh, 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 adjudications, this is also the extreme case of, let's say, counter-majoritarian difficulties, etc. And this calls for some kind of political backlash to restrain the court in many ways. So I just wonder what is your take about any implications that this BBI case might have on judicial independence. Thank you very much.
And thank you, Yaniv. Esther, please.
All right. Well, you have all had your eyes on Kenya for, I think, pretty much the last 3 or so months because of the BBI. I'll say this. I don't know how many of you followed more than just the case and the outcome of the case, but we have had judges who were yet to be sworn in to office as either judges of the Court of Appeal or judges of the Environment and Land Court, which is a court of equal status as our High Court, but whose jurisdiction is limited to matters land and environment and related issues, or judges of the Employment and Labor Relations Court, which is equally of equal status to the High Court. And if you're following, you may have seen that out of the list of judges that were to be sworn in to take various duty stations, either as Court of Appeal judges or High Court judges, some were not sworn in. And conspicuously, 2 of those were judges who were on the bench that decided the High Court matter. Of course, without going into the details of it, there is great concern that that failure to swear in all the 6 judges is unwarranted, and specifically the 2 that were part of this bench, and therefore, yes, it is seen by many in Kenya as a direct assault upon the independence of the judiciary, and more so the independence of individual judges as they sit to make a decision, because then the thoughts that would come to one's mind as before you determine a matter is, okay, is there a favor that I need, or is there do I have a pending swearing in or promotion? That has come up, and I'm sure perhaps your question arises from those subsequent events, and of course those events coming right after the delivery of the High Court judgment and just before the hearing of the Court of Appeal, the Court of Appeal, the appeal by the respondents in the High Court, means that it could be a message that's being passed to those that may wish to exercise their judicial independence as individual judges, that there could be implications to some of the decisions that you make. As you say, it is important to have that balance between making the courts the final determinant of what the society is about or what the people can or cannot do. But I believe that we are in a fragile place as a country, considering that it is not, this is not new. The assault or the subtle and sometimes obvious attacks on judicial officers is not new in our country. And if you followed the news again, I think we had 2 other judges whose chambers, police stormed the chambers of a judge in 2021. It's ludicrous, but it's happened. So we understand some of these things, and my hope and I believe I have confidence that we have men and women of integrity, of conviction, who will do what is right. It doesn't mean that they must uphold the decision of the High Court. It doesn't mean that they must rule against powerful forces. It just means that if, with all the facts considered and the law, they truly believe that this is the right determination to arrive at, they will do that without any fear of implications thereafter. But we understand the country that we live in. I think I'll just say that we understand the country that we live in, and we also know that we are moving into an election year in Kenya, and there's so many dynamics that are going on around the political space. And because, again, all political disputes or election disputes all have to come back to the courts. So it may not be specific actions targeted towards just the BDI appeal, but also towards decisions that may need to be made in about a year or the period between now and a year or a year and a half from now, when we may have electoral disputes that are quite high caliber. We may even have another presidential election petition. So you can't close your eyes completely to some of those issues.
And the world will be watching. We will all be watching. Esther, our time with you is almost done, and I regret that very much, because this has been really fun to learn about you and to chat with you and to have the chance to be your interlocutor for the past 55 minutes or so. But I have to ask one more question, which is about one of your hobbies, I understand, which is singing. Is that correct?
Singing?
Yes.
Yes. I lost you for a bit. Yes. Yeah, singing.
Yeah. Tell us about your singing and what kind of songs you sing, and if you write your own songs, if you play instruments, if you have recordings anywhere that we might find if we go on YouTube.
No, you wouldn't find any recordings. I don't think you would. We
can make one now together if you wish.
Yeah, that would be nice. That would be nice on a light note. But I grew up in a family of musicians. My grandmother sings in the choir. We are Seventh-day Adventists, and they are my whole family, they are very faithful Adventists. And my grandmother sings in the choir, my cousins, my aunties, my grandfather composes, he writes music for the choirs. So pretty much I grew up in a home full of music. I think my aunties played the piano. I played the piano when I was younger. I am swamped with being a lawyer now, so I hardly have the time to sing or go back to it. But I have been considering, as a stress reliever, I've been considering actually recording something. So you might have something coming your way soon. And I hope I can get a few maybe on the platform or elsewhere who would be willing to collaborate with me on a piece of music.
I
Yeah.
love it. I love it. I love it. You know, I play the saxophone,
Super.
alto saxophone. So if
My son plays the violin. He's learning to
Okay.
play the violin. So yeah, we
got
could
the
do something.
violin, saxophone, voice, yeah.
Perfect.
Esther,
Perfect collaboration.
Esther Ang'awa, advocate of the High Court of Kenya, our first inaugural guest in this series on global leaders in law. What a pleasure to have the chance to speak with you and to introduce you to some people who might not have known you, but now certainly will never forget you. Thank you so very much, and thanks to all for being with us today.
Thank you. I think I must say thank you, Professor, for this. I mean, you began a series, and you felt that you would honor me with being your first guest. I must say I am extremely humbled. I think, as I have told you a million times on Messenger, it was an honor that you replied to my tweet, my DM, and provided very useful material that helped me in the brief, but also that you have become more, and for sending me a hardcover copy of your book signed. I mean, I'll cherish that for many, many, many years to come. I hope Rosnai is taking notes. Rosnai, you would like to, sign one of yours, and I'll send you my address. I'd really love to read more of your works. And really, thank you very much for paying attention to what's happening in my country, paying attention to our processes and what impacts they seem to be having and will probably continue to have on constitutional law across the globe. I think it's an honor to be a Kenyan at this point in time, and it's an honor to be part of that history in making. So thank you again for the opportunity. Thank you to the University of Texas for giving audience to a young girl from the lakeside. I actually come from the lakeside. Like, I open the window and I see the lake.
Oh, beautiful, beautiful, beautiful. Well, I wish you great success, and I wish you many vacation days by the lakeside, if you can manage to do that with all of the work you have on your plate.
In a few weeks, perhaps, or months, maybe after the judgment, I can see my mother online. If you wouldn't mind, just if she could just
Of
say
course,
hello.
of course. How and who is your mother? I'm not sure.
My mother is Janet Awidi.
Okay, great.
Let me just thank her for
Of course,
giving birth
please.
to me.
Let us see your mother, hear your mother, please. Hello.
Mom, if you can turn your mic on and say thank you to Professor Albert for giving your girl a global platform to talk to amazing human beings from.
Well, we're the ones to thank your mother.
Well, it seems she is.
Hello.
Oh, super.
Hello.
Hello.
Can you hear me? Hello.
We
How
can
are
hear
you?
you. We cannot yet see you, but we can hear you. Please, the floor is yours.
Hey, yeah, I've not turned on my video today. Thank you.
That's okay. But congratulations. We're so grateful to you and to your entire circle of family and friends who helped to raise this wonderful lawyer who is captivating the entire world of public law, not only in Kenya, but around the globe. So congratulations to you.
Thank you, and thank you also for giving her this platform just to showcase what she's able to do and show her abilities to all that are listening and watching.
For us,
Thank you.
For us, it is an honor and a great pleasure, and also to hear from you. So thank you for being here. Esther, thank you once again for joining us. This has really been great. And thanks to everyone. We'll announce our next guest number 2 in this series on global leaders in law. And so stay tuned. But for now, thanks to everyone. Stay safe and have a good afternoon. Bye-bye.
Good evening. Asante sana.
Bye.
Asante sana. Bye-bye.